In the legal world, international arbitration is a growing field. As businesses increasingly become global, their legal battles in the form of arbitration are also being fought across national borders. Our globalist today is Kim Kap-you, or Kevin Kim, managing partner and the Kim behind Peter&Kim, Korea's largest law firm specializing in international arbitration. Mr. Kim is here to take us into the world of global arbitration. We will discuss the great rewards as well as the great challenges and what role Korea and his firm will play in its future. So welcome to the Globalist.
Thank you for inviting me.
You've been flying across the globe, and we're very glad that you took the time to join us today. First off, international arbitration is not a commonly known idea. What is it? I mean, is it different from going to court?
We have to define what is arbitration is about. Arbitration is litigation by private person. So litigation is by judges of a particular country, while arbitration is same type of resolution as litigation, but by private person.
So instead of a court where there are judges and lawyers, it can be anywhere?
Claimants and respondent, when they agree to bring their dispute to the private person rather than to the court, that is arbitration. So in the place where it happens, it can happen in a hotel, conference room, or classroom.
Or Zoom?
Or Zoom, of course. But nowadays, there is many arbitration institutions who provide the service for arbitration. So we normally use the facilities.
Okay, so in what case does arbitration happen? I mean, what kind of legal problems are resolved through arbitration?
Almost everything you can imagine in dispute, you can bring to arbitration, particularly new areas. For example, crypto business, very complicated financial transactions, game industry, bioscience. They want their dispute can be resolved by someone who knows the industry. So they have more demand that they agree to arbitrate by private person rather than going to the court. And in terms of international transaction means two parties in different countries, belong to different countries. So one party want to go to one country's court, and the other party feel very uncomfortable to go to the court. For example, if you go to Abu Dhabi court, for example, Abu Dhabi court will proceed in Arabian language.
Okay.
Then American party will be uncomfortable to go there because you don't understand what they're saying, and you're not familiar with the system, you're not familiar with the procedure, and you cannot use your own lawyer. Because only UAE qualified lawyer can appear the court.
Yep.
While international arbitration, you just go to private person, and any lawyer can represent parties' interest in the case. So you bring in your lawyer, and you proceedings in the language you can understand. Most cases in English. So that is the very strong demand in international transactions. So most international transactions, and people tend to agree international arbitration. So in many cases, there are three arbitrators. So one party appoints one arbitrator, the other party appoints another arbitrator. These two co-arbitrators agree, presiding arbitrator, then three members panel, and they decide everything about that that case.
So what is a lawyer's role in all of this?
A lawyer's role is that, first of all, you represent parties' interests. In that case, we call it counsel. I've been a lawyer almost 40 years. Main work I'm doing is counsel work. But I also serve as arbitrator in some cases. So because when parties appoint me as arbitrator, then I act as arbitrator in different case. So that is a mechanism that parties can choose whatever person they believe that is qualified and right person to sit as arbitrator in the case. When you go to the court, you cannot choose a judge.
Yeah.
Judge will be allocated
Appointed, yes.
and assigned by the court. But in international arbitration or the arbitration, you can select your own judge. So this judge more knowledgeable about a particular area, then you can choose it. Or you want some more quicker, speedy, efficient dispute resolution based upon the reputation or the experience, then you can choose that private judge in international arbitration.
I see. So tell me about some of the cases. You talked about cryptocurrency, online gaming, but it's not these small cases we're talking about, right? I mean, we're talking about big companies, especially some of the very first ones that your company handled. They involve big corporate companies.
I would say most big disputes in the world resolved by international arbitration.
Really?
Including case against government.
Oh.
Maybe you'll be familiar with 론스타가
Yeah.
versus Korea arbitration, very much covered by media.
Yeah.
That is arbitration. They call it exceed arbitration. It's an investment treaty arbitration. The country agreed to arbitrate when investor want to go to the arbitration.
But then what about enforcement? What if the state says, I don't want to agree to what has been agreed to?
In terms of commercial arbitration, like dispute between two private parties, there was international convention called New York Convention, which is UN convention, which was executed in 1958. That guarantee enforcement of foreign arbitral word in a particular country. So arbitral word, we call the word rather than judgment. This arbitral word can be converted into the judgment in a particular country when the winning party go to the court. They say, I want to convert this arbitral word into the judgment. That was guaranteed by international convention.
So does arbitration have a winner and a loser? Or is it somewhere in the middle?
Many people believe that arbitration is something in between.
Yeah, I mean, because we think it's negotiating of something.
But arbitration is exactly the same as litigation, while the mediation is something the mediator persuade parties to
negotiate
agree.
and
Try to agree in the middle ground. So as judge decide the case based upon the law, arbitrator exactly apply the law and make a decision. And it's arbitration, you have no appeal.
No appeal.
So once you decide, there's a final decision.
Wow, that's harsh.
That's harsh.
That's harsh.
But international transactions, the parties want to resolve dispute as quickly as possible. So that's why they agree to arbitration, and they just make a lot of investment and time and effort to resolve the issue as one single stage. And once it's decided, it should be binding to both parties.
So how big is this market? Is it a very growing market? Are there a lot of businesses who prefer this type of legal process?
Yes, when it was introduced, like maybe the start of 20th century, it was quite slow until 1990.
Okay.
And it became rapidly grow, particularly in Korea, when you have financial crisis in Asia from 1997. There are so many international transactions, and merger and acquisitions or other transactions was done within very short period of time. Most contract has arbitration clause. That is start of international arbitration in Korea.
You are one of the leaders in this area globally, not just in Korea. So what was your first arbitration case, or can you tell us about an arbitration case that sort of you felt you made a difference?
First arbitration, of course, I clearly remember that. I started my practice 1988, and I was doing a lot of corporate work, M&A, and also have litigation. And we have financial crisis. 1997. That was after I got LLM US and qualified in New York and came back to Korea as 1995. Then some year later, we have financial crisis. Then we have international arbitration arising from the transaction. At that time, I was working for a big law firm, and somebody just asked me to take the case because I did litigation.
Yeah.
I know M&A transaction. So I'm familiar with the litigation proceedings in the common law countries. So they believe that I'm the right person. Yeah. I say no, because it was absolutely new to me. Oh. And even that time, I was quite well-established lawyer in Korea. So I'm quite confident I can do a proper litigation practice in Korea. But why I should be embarrassed to plead the case in English before the international tribunal?
Whole new field.
Yes. So I say, oh no, I'm not going to do that. But somehow there's kind of pressures or situation. So I have no option but to present international arbitration proceedings. And I found that only Korean lawyer can properly explain what is the Korean law, and the Korean lawyer who understand common law to explain the difference, how the concept is different. That concept of the Korean law is a very, very unique one in a continental civil law system. So it's very difficult to explain. So only Korean lawyer can properly explain it, and we have Korean witness and dealing with the Korean language written documents. So when it's translated into English, there's many misunderstandings. For example, we actually quite mixed up with my. Yeah. The really good example is my wife. We call it our wife.
Yeah.
Right? So that
the wording,
So we have to explain that when you say in Korean they or we, not necessarily the group of people, sometimes it means just an individual. So I found that only Korean lawyer can properly represent Korean parties in such a setting. So that's why I volunteered that, okay, I'm going to do this. Yeah. And then I won the market in Korea because I see that other countries, there is some famous person, but no market. Then you have no way to read the market. Yep. So I shared all the information. I encouraged them, I helped them establish arbitration practice. Then the Korea became very big market in international arbitration.
Why did Korea become such a big market for international arbitration?
70% of our GDP coming from outside Korea. So naturally, Korean companies are very active in every countries. So when they have dispute, they need go to international arbitration. And Korean companies are very open-minded to take new things. So Korean companies became biggest user in international arbitration in Asia. For example, when you compare with Japan, we have more than double numbers arbitration than
Really?
Japan. While Japanese economy is much bigger,
Yeah.
we have very similar numbers with China, which is also a very big economy. And we have many arbitration experts, arbitration lawyers in Korea. And we have many cases, many practice, even professors, arbitrators. So Korea is now leading arbitration market in Asia.
Having such a big arbitration market, does that help Korean companies? I mean, because of the arbitration market here, they're allowed to grow and be successful?
Yes, it's a very important to Korean companies because when Korean companies involved in international arbitration, you will be assisted by the experienced counsel. And when you go to the arbitration, the arbitrators know that, Korea is a big market. So Korean companies are quite important players in the market. And you have, in a dispute, you have to show your image. Actually, the Korean wave is quite important in international dispute because at the end of the day, when you're dealing with a witness or expert in a particular country, you're always thinking about how much you can believe that person, how much is reliable. So the reputation is very important. So that Korea have big arbitration market means Korean companies are benefited bringing the case in the international arbitration or pursue the claims or defend the claims. They feel more comfortable than other countries.
Can you cite an example? I know ongoing cases are not available, but maybe a past case in which a Korean company benefited from this process?
Because of confidential, I'm not going to mention the
Okay.
company name, but we had a case where the whole company ownership transferred to Korean company from foreign company to Korean company as a result of arbitration. Also, we have the case, even U.S. litigation, we represent Korean parties in U.S. litigation, and we won. In normal U.S. litigation, you cannot cover the cost, but that was very quick procedure, like it was done within a year. Our client won and recovered all the costs. So international arbitration is very intensive procedure. So you naturally spend some cost and time, but if you have right position, you're entitled to recover all the costs from the side. So there is many cases involving $1 billion. The Korean parties have very good experience. They win the case either as claimants or respondent.
It sounds like you need a very highly qualified team in order to be able to do this. What does your team look like? It feels like it would be very diverse.
Yes, exactly. We have office in Geneva, Zurich, Seoul, Singapore, and Sydney. We have lawyers from all different countries. We cover 19 different languages on those jurisdictions. But even in Seoul, we have lawyers, of course we're Korean lawyers, originally from France, but qualified in US. We have Singaporean lawyer. We had an Indian lawyer. So whoever is interested in international dispute, it doesn't matter where he or she qualified. It will be beneficial when somebody speaks more than one language.
True.
The team is very much multinational and multicultural.
But beyond the language or even the legal background, what do you look for in a lawyer that would be an arbitration lawyer?
You need to have good analysis of the law, but you have a better sense to present your case to the tribunal. So I would describe international arbitration as kind of making a movie or the drama, because the thing already happens. So you can't change the fact, you can't change the documents, but you just make the story, make up story, present it. It's like the opera, all the songs already fixed. You You already have
Yeah.
songs and what it's going to say, but how you present make the difference. So our role is we present our case to the tribunal in a way the tribunal understand the point. When you say 0, O means yes in Korea, X means no in Korea. But people only recognize that is case in Korea when they see the Squid Game.
Yeah, that's true.
Until there's a Squid Game, X means yes in US, and they have no idea why they put O and X and the triangles in the Squid Game.
Yeah.
You have many things to explain the difference between the cultures and different laws. So I'm looking for someone who properly understand the difference, different cultures, different law, and ability to explain properly to the tribunal.
That's a very unique skill, though.
Yes.
But you tell me that you see potential in Korea and the lawyers that are coming out of Korea, that you see the future of arbitration being very bright?
Yes. First of all, Korean companies go all around the world. So we naturally have a lot of cases all around the world. I think we have mission to protect Korean companies' interest as Korean lawyer, so that Korean companies have properly protected by its own lawyers. But the other bright side, I see that our young generations, they're so bright, and they're really good in language skill. Now we have many people who is absolutely fluent English and exposed to international culture, international settings, so that they have real capacity to dealing with international matters. And traditionally, Korean society make a lot of investment, human resources in the legal section. And also, we have very good court system, very reliable court. However, we didn't have international appearance. Let's say there was a very famous person who read the market, or we just write a very famous book, everybody follow that. So with this young generation, I see that we can make so-called KLegal, I describe it, because the law we have is combination of the civil law and common law. We just put it together based upon our experience.
And our needs.
Yes. So that is similar to the K-pop. It's not necessarily our own tradition, but we just bring in the good tradition in order to adapt the situation. And we have like very short period, a lot of experience dealing with the issues. So we are the only society within 60 years, dramatic difference of human rights issues.
And the legal system.
And the legal system, and the law, and we adopted many good things from other countries and practice it. What I'm doing now is I try to introduce the Korean practice to international practice. Just say that we are doing this in Korea. We found it very efficient. So I already have good response from the market. Just say that some people say that, oh, that is really good idea, quite good practice.
Because of pioneers like you, I'm sure the future for young Korean lawyers who want to be arbitrators is quite bright. No?
There is a lot of people interested in.
Yeah.
I'm really happy to see that.
Yeah.
But in Asia, it's a huge market. The Asian countries, most countries have a civil law tradition. The law is very similar to Korean law. And we are in a very good position because we are surrounded by big countries. So when these big countries try to find a neutral place with good legal system, we are really good country because in Asia, not that many countries have stable legal system with the rule of law strictly apply. Also, our lawyers, as a major player, make a contribution and they read the market.
Yeah.
So I'm joking that the fencing and international arbitration is some common things that was invented by French, but we are best in the market in Asia.
No,
So
that is true. That is true. And hopefully we'll see much more of that in the future. And come back and tell us how it's going.
thank you.
And that's it for me. I'll be back next week with another globalist who's putting Korea on the map. Sun Ji out.